explain the scope of freedom of religion as guaranteed under Constitution of India? Or, in what manner is our Constitution secular? Examine the constitutional limits in which religious freedom is avoidable to an individual in India. Ans. Articles 25 to 28 of the Constitution of India deal with the fundamental rights relating to freedom or religion. Their rights are guaranteed to all persons and not merely to citizens. India is a secular state and therefore no preferred religion. All religions enjoy the same constitutional protection without any discrimination. Constitutional provisions. Article 25 provides that all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion subject to public order, morality and health. Article 26 says that subject to public order, morality, and health every religious denomination or any section thereof shall have the right a. To establish and maintain institutions for religious and charitable purposes. B. To manage its own affairs in matters of religions. C. To own and acquire movable and immovable property, and D. To administer such property in accordance with law. Article 27 of the Constitution provides that state shall not compel any citizen to pay any taxes for promotion or maintenance of any particular religious institution. Article 28 lays down that no religion's instructions shall be given in any educational institution wholly maintained out of state fund. Meaning of religion. The word religion has wide connotation. Religion is a matter of faith with individuals. Religion lays down certain code of ethical rules for the observance by its followers. It is not confined to religious belief but extends to various rituals and ceremonies and modes of worship which the followers of a particular religion consider necessary and conducive for the members of their community. In S.R. Bommai v. Union of India, 1994, 3 SCC 1 Supreme Court has held that secularism is a basic feature of Constitution. State treats equally a religious and religious denominations. Religion is a matter of individual faith and cannot be mixed with secular activities. Secular activities can be regulated by state by enacting a law. Restrictions on the freedom of religion. The freedom of religion is subject to following restrictions. 1. Public order, morality and health. Nothing can be done in the name of religion which will adversely affect public order, morality and health. In Ghulam Abbas v. State of UP, 1984, 1 SCC 81 Supreme Court has held that shifting of a property, grave, connected with religion to avoid clashes between two religious communities or sects is valid and does not affect religious rights being in the interest of public in general. An order under Section 144 of Criminal Procedure Code prohibiting such a procession in the interest of public order and morality is not violative of Articles 25 and 26 of the Constitution. 2. Regulation of secular and financial activities. Article 25, 2a, provides that nothing shall affect the operation of any existing law or prevent the state from making any law, regulating or restricting any economic, financial, political or other secular activities which may be connected with religious practice. In Mohd Hanif Qureshi v. State of Bihar, AIR 1958 SC 731, it was held that slaughter of a cow on the day of Bakrid was not an essential element of Muslim religion and hence could be prohibited by law. 3. Social reforms. Article 25, 2b provides that the state is empowered to pass a law providing for social welfare or social reforms or throwing open of religious institutions of a public character to all classes and sections of Hindus. Under Article 25, 2, state can eradicate social dogmas which stand in the way of country's progress. In State of Bombay v. Narsu Appamali, AIR 1952 Bong. 84, an act which prohibited bigamy was held to be valid under Article 25, 2b. Thus, where there is a conflict between the social need and religious practice, religion must yield. Hence, the freedom of religion is confined to only matters of religion, and state can regulate secular and economic activities connected with religion. In Ismail Farooqi v. Union of India, 1994, 6 SCC 360, the Supreme Court, by a majority, has held that the state can, in exercise of its sovereign power, acquire places of worship like mosques, churches, temples, etc., which is independent of Article 300 of the Constitution if it is necessary for maintenance of law and order. Such acquisition per se does not violate Articles 25 and 26 of the Constitution. What is protected under Articles 25 and 26 is a religious practice which forms an essential and integral part of religion. A practice may be a religious practice, but not an essential part of religious practice. While offer of prayer or worship is a religious practice, its offering at every location where such prayers can be offered would not be an essential religious practice. Status of mosque in secular India is same as and not higher than that of places of worship of other religions such as temple, church, etc. A mosque is not an essential part of the practice of the religion of Islam, and namaz, prayer, by Muslims may be offered anywhere, even in open. The right to worship does not include the right of worship at every place, so long as it can be practiced effectively, unless the right to worship at a particular place is itself an integral part of that right.